I'm going to talk today about the Rehabilitation of Offenders Act 1974. Now, the Rehabilitation of Offenders Act 1974 sets out the period of time that must elapse after which an individual need not tell a potential employer about their conviction. The first thing to say is that there are certain jobs that are excluded from the Rehabilitation of Offenders Act. So, for example, an individual applying to work for the police, or applying to work as a nurse, or applying to work as a doctor or as a teacher, they would be excluded from the provisions of the Rehabilitation of Offenders Act. But for jobs that are not excluded from the Rehabilitation of Offenders Act, the legislation sets down the period of time that must elapse after which an individual need not tell their potential employer about their previous conviction. Now, the law differentiates between whether an individual was aged 18 or over or under 18 at the time that their court matter was concluded. And the general rule is that if the individual was aged under 18 at the time, then the period of time is generally half that of the adult. So the period of time is determined by the severity of the sentence. The more severe the sentence, the longer the period of time that must elapse. At the top end of the scale, if an individual, whether they were aged over 18 or under 18 at the time, if an individual received a custodial sentence of more than 4 years, then the rehabilitation period never lapses. So they are always required to tell a potential employer if they receive a sentence of more than 4 years. The next level down is 7 years for an adult and 3.5 years for an individual who was aged 18 or under 18 at the time. The key point to note is that this period starts to run at the end of the sentence, including the licence period. So once the sentence, including the licence period, ends, then the Rehabilitation of Offenders Act comes into force, and it's then that there is a 7-year period. So that's for individuals who are sentenced to less than 4 years, but more than 2.5 years. So if it's more than 2.5 years, less than 4 years, the period of time is 7 if they are 7 years if they are aged 18 or over at the time, or 3.5 years if they were under. The next period of time is the 4-year period. So if the individual received a sentence of more than 30 months imprisonment but less than 2.5 years imprisonment, then if they were aged 18 or over at the time the sentence was determined, then they must wait 4 years before they need not tell a potential employer. If they were aged under 18 at the time, then they must wait 2 years. The next period of time is a custodial sentence of less than 6 months. In that situation, then at the conclusion of the sentence, at the conclusion of that 6-month period, including the licence period, the length of time is 2 years, 1 year if they were under 18. Below that, the non-custodial sentences. So if it was, for example, a community order, the period of time is 1 year if they were over 18 at the time. You then get into even less serious offences. So, for example, an absolute discharge. Well, that's absolute in any case, so that means that the Rehabilitation of Offenders Act doesn't even kick in. A caution is spent immediately. A conditional caution is spent once the conditions of the caution have been complied with. So, in summary, the Rehabilitation of Offenders Act 1974, it sets down in law the period of time that must elapse before an individual need not tell a potential employer of their criminal conviction. There are exceptions, particular jobs are exceptions to the rule. So for example, working in medicine or working in teaching, they do not apply, they are excluded under the Rehabilitation of Offenders Act 1974. And the period of time that must elapse is determinant upon the severity of the sentence.